And I can take roll. Hardston?
Here.
Kirkmeyer?
Here.
And we know that Fariba is joining a little bit later. So we have a quorum and can start. And I can look to see. Oops.
It looks like we have two.
Looks like we have.
Do any of the attendees want to make public comment?
It doesn't look like it. If you, I think that these are people that the attendees know that how to raise your hand in Zoom if you'd like to comment. I don't see any raised hands.
Okay. I am going to go ahead. Andrew.
Sorry, would it be helpful to shoot Greg an email really quick if we haven't done so?
Yeah, I'm actually going to text him. Let me do that. Okay. What I had talked to Greg about doing in this kind of 45 minutes before Fariba comes is spending our time not really going over decisions that have been made, but kind of inventorying or cataloging outstanding policy issues to be determined, vetted, so that we can think about that in relation to the upcoming, the June meeting of the full working group, and kind of map out what you all want to tackle at each meeting. Because we spent a long time at the last meeting on really a couple of issues, not fair to say one issue. But I'm starting to be a little bit concerned that we may not get through everything. And so I thought it would be helpful to map out what everything is. I'm a bit at a disadvantage right now because Greg was generating that list of what the everything left to do was on the rules issues. But I think
there he is.
Okay.
Hi everyone. Sorry about that. I had another call that just went over.
Oh, that's okay, because I said I'm a bit at a disadvantage because for the beginning portion of this meeting, we were going to talk about what we have left to do. And I was relying on you to generate that list. So I thought we could do that with this beginning portion. And then Kim and Amos, I thought it would be helpful, though it may make sense to wait for Fariba as well, for Greg to just go over again kind of the regulatory construct for attorneys, which is this odd, mix of rules of professional conduct, state bar rules, rules of court and statutes, just to kind of reframe that structure. So that's what I was thinking for this initial, at least for the initial 40 minutes before Fariba joins. How does that sound?
That sounds fine to me. Is there anything we need to do in advance of Monday's meeting on fee caps? Because I think we haven't talked about that for a while.
Sure. I don't know if you all, and Linda, I was reminded that I think we committed to sending out an email to the group when we posted items to the agenda, because some people didn't seem to be getting the automatic notifications.
Okay, I can do that.
I think we said we would do that each time now going forward. So last night or yesterday, Linda posted the items for the fee, the item for the fee meeting, which is really just a sort of reflects all the staff legwork that's been done. So we could certainly go through that or talk about it.
Yeah, if it's useful. I mean, where we left off, I think, was the regulations subcommittee didn't have a recommendation. And so it's really an open discussion of those issues. So just wanted to raise it in case we wanted to talk about how that was going to be presented or what materials, but I sort of defer whatever you think is going to lead to the most useful discussion on Monday.
Okay. So should we start with trying to figure out our to-do list for this subcommittee?
Sure.
Okay.
And Leah, I sent you that list of rules that I think still need to be addressed in some way by the subcommittee. Do you still?
I didn't get it.
You didn't get it? Oh, I'm sorry. Let me check. Let me. I sent to you yesterday.
Do you want to screen share it right now?
Oh yeah, let me try to do that. I haven't, no, this is going to be interesting. I've never done that before.
Oh, you have?
I'm always the recipient of
The
screen
big-
sharing, not the screen
Big
share.
moment for you, Greg.
You might be looking at the wrong place in your, I can just see from your eye level that you might need to look down.
Yeah, I'm looking at my other
Okay.
screen right now.
Okay.
Okay, let me pull it up here. Because I have 3 monitors, so okay. So maybe if I pull it over here and then
3 monitors does not sound like a state employee.
oh, we all have 3 monitors at the we all have at least 2 monitors, and now we all have laptops. So that's the 3rd monitor. Okay, so I want to share. Oh, I see. Okay, so I can turn that off. Bring this back over here. Who knows? It may be faster to just send it to you. But... Okay, I tried it this way. Share screen out here. Okay, can you what can you see now?
We can see it.
You
Maybe,
can see,
yeah, it's, maybe you can try making it single page view or bigger.
yeah, let me see, I could do that. View.
You click page width. Yeah, go. We're under straight down from view.
Oh yeah. What if I do this? There. Can you see it now?
Yes.
Okay. Okay, so I made this list of, I just went through the rules where Kevin, Professor Moore had some issues. I also flagged rules where I have outstanding notes for this subcommittee. A lot of these things are not major issues, but they're issues that we need, I hope they're not major issues, but they're definitely areas in which we need weigh-in from the subcommittee in order to draft the rule. I won't go through all of them now, but I think there's 17 different rules that we need to, and some of them we've already started to talk about, others we haven't. So I'll just show you the full list here. And then near the bottom, I also included this topic of addressing the comments. So Kim, just so you know, when we began looking at the rules of professional conduct for lawyers, which were just approved by the court in 2018, after a very long and arduous process. So they were approved not too long ago. So we thought the best approach would be for rules of professional conduct for paraprofessionals to make that our starting point, since the court had weighed in on a lot of public policy that underlies those rules, and I imagine would want the rules to be as consistent as possible. But the comments, the comments were a bit of an obstacle to the Rules Revision Commission, certainly the first one, which had that Rules Revision Commission had taken the approach of adopting a lot of the comments from the ABA model rules, which can go on for each rule for pages and pages. And a lot of it really didn't serve the function of comments for the California rules historically, which has been to elucidate the rule and provide some interpretive guidance to lawyers. And the fact that they were so lengthy, I think the court concluded this is not as helpful as it could be. So the second Rules Revision Commission really took the direction from the court to limit the comments as much as possible, but still we have a lot of comments to the lawyer rules. And so rather than trying to wrestle with those right out of the gates, we decided let's set aside those comments for now. But now that we're getting to the point where we're developing a final set of rules, I think we need to turn our attention back to the comments. And you will see in the marked up version of the rules, there are particular instances in which I have suggested that we add some commentary that's particular to that version of the rule that the regulation subcommittee is going to recommend to the working group for paraprofessionals, where we diverge from the lawyer rules, or where the application of the rule to a paraprofessional licensure might require some additional commentary beyond what we have for the lawyer version. But for the most part, I think that a lot of the commentary for the lawyer rules would probably just need some conforming changes. I would imagine a lot of it includes citations to case authority on the topic of the rule. And I think in most cases, the court would probably view that as persuasive in interpreting the rules for paraprofessionals. And then any other areas in which we need to identify additional commentary. So that's something that's still on our plate that we probably need to address at some point. And the last item I have, and I've been trying to keep a list of these things, are areas in which we may have to propose changes to the lawyer rules of professional conduct. And those are conforming changes. So to the extent, for instance, paraprofessionals will be permitted to practice with lawyers in the same law firm, we're going to need to make some conforming changes to reflect that in the lawyer rules. And so those have been noted, I think, along the way, but there may be some additional ones that we need to flag. So that's where we are. And then so in terms of putting together a work plan, I think we need to, between now and June, the meeting in late June, I think June 17th, Leah, is that right?
When is the, that's what I was just looking at. When, Linda, is the June full working group meeting? Is it the 17th or is it the 25th?
Oh, is it
It's
25th?
the 25th.
I think I had the 17th in my mind from the prior April meeting. Okay, so I think we could use this as a basis for trying to map out a work plan going forward in terms of just trying to complete the rules of professional conduct, if that makes sense.
That sounds great, but just to be clear, these are the disciplinary rules, the rules of professional conduct, and we're also going to need to do rules of court and proposed legislation. Are we planning on doing all of that for the June meeting, or are we focused on the disciplinary rule?
Just the rules of professional conduct.
Yeah, I think that the rules of court, and we can get into this because I think it would be helpful to, once again, kind of take a step back and think about how we regulate lawyers and how we will probably try to stand up this program with the help of the legislature. All of the work of every one of the subgroups is going to affect the rules of court and statutory changes. So for instance, I think certainly the licensing subcommittee and as well as all the substantive areas, because there's going to be licensing requirements, specific licensing requirements based on the type of licensure, which will probably migrate either into statute or into a rule of court, or both. It could be both. And so that's something I think it goes almost beyond the scope of just the regulation subcommittee. I think the entire working group is going to have to address how exactly we set forth the licensing requirements, the disciplinary infrastructure for the program, as well as the governance structure, and then the particular licensing and scope of practice areas for each. What are we calling them? Endorsements or form of licensure.
And just as a reminder, that's there's this OGC team that's been assigned to work on those different pieces, using the decisions that have been made so far with respect to discipline, licensing, etc., to begin drafting. And that work is slated to come to the full working group. I believe in June, you're going to see some policy questions teed up by that OGC team, but not any kind of draft to view. And prior to that time, at one of the meetings of this regulation subcommittee, they will be bringing some of those issues forward. So I think it's safe to say for now, our main task is just trying to finalize the set of rules of professional conduct.
Can I just get a clarification from non-attorney on the rule? What's the difference? So you have the rules of professional conduct, which is more your disciplinary. The rules of court, is that just like the other regulations that you know, give authority to the program, and then you have your statute. Okay.
Yes. And and Leah had asked me to give a bit of an overview about how attorneys are regulated through the cooperative partnership between the legislature and the court, which I think might elucidate that a bit. Do you want me to do that now? And I can also send you this list so that everyone has this list. We can certainly add to it if anyone sees anything in the rules that they think that we need to address between now and June 25th as well.
Yeah, I think it probably would be helpful for you to go into that a little bit now, Greg, just so Kim has context for what we're doing. And then if you could send the list.
Yeah.
Okay.
And I just wanted to say hello, everybody. I'm here.
Oh, you're
Hi, Frida.
early.
I am early. It was a good time to leave.
Okay.
The dreaded role play.
Okay.
Okay, I'll try to do a brief, do this quickly so that we can use our time now that we have Fariba here, but it may be helpful for everyone to kind of remember. I think I had a soliloquy in one of the early meetings, just giving an overview of how attorneys' admissions and discipline is regulated in California, which is a bit different than other states, in that we really do have a working partnership with the legislature in this area. So the power to regulate the practice of law in California, and which includes the power to admit and discipline attorneys, has long been recognized to be one of the inherent constitutional powers of the court. And the Supreme Court has that exclusive power over admission. And so the court historically has also respected the exercise of the legislature under the police power to have a reasonable degree of regulation and control over the profession and practice of law. They can be reasonable restrictions upon the constitutional functions of the courts, provided they don't defeat or materially impair the exercise of those functions. And statutes that regulate attorneys are considered at best minimum standards unless the court is satisfied they are sufficient. So there are several instances in which through the State Bar Act, the legislature imposes particular duties upon attorneys, and the court hasn't, in that particular area, has added through rules of professional conduct or rules of court additional obligations. So let's talk about admission. So the legislature has the authority to determine the qualifications for admission, and those are set forth in the State Bar Act. And additional requirements may be imposed through state bar rules, but they must be approved by the court. So in terms of admission standards, you look to the State Bar Act as well as state bar rules. There are examples, they're not recent, in which the court has determined that the legislature has overreached. I'll give you a couple examples. One, in Ray 11, there was a pardon statute that allowed an attorney that was disbarred based on a conviction of a crime the right to practice following an executive pardon. And the court struck down that statute because it considered it an intrusion upon the inherent power of the court to admit attorneys. And the court, despite the fact that the pardon was provided, the court still needed to determine that the person had met the moral character standards to be admitted back into the practice of law. Another example was when the legislature bestowed the power upon the Workers' Comp Appeals Board to remove or to suspend or deny the privilege of attorneys to appear in its proceedings as part of its contempt proceedings. And the court ruled that the legislature had overstepped there and its traditionally recognized authority, and struck that down as well as a violation of the separation of powers. And one other example, in Merco Construction Engineers, there was a provision in this Code of Civil Procedure authorizing corporations to appear as parties in proceedings in court, and which essentially was allowing non-lawyers to practice law in court. And the court struck that down again as offending the separation of powers clause. So these are not recent examples, which I think is a really good sign that the court and the legislature has a working relationship in this area, we haven't had the occasion, fortunately, to have that type of intrusion upon the court's constitutional authority. Now, the court regulates attorneys also through Title IX of the Rules of Court, and those are the rules on the practice of law, attorneys, and judges. Rule 9.0 states that these rules are adopted by the court under its inherent authority over admission and discipline of attorneys and under the California Constitution. Most of the rules of court usually go through a process through the Judicial Council before they're approved by the court. These are the Title IX rules, as well as the rules on publication under Title VIII, are promulgated solely by the court. And so, to the extent the court would have to authorize paraprofessionals to practice law in the state of California, most likely those rules would appear under Title IX. And some other Title IX rules that you may know of are the rules pertaining to permitting appearances and practice of law by non-licensees of the state bar, which is essentially an exception to the UPL statute, Business and Professions Code 6125. And those rules set forth the requirements for qualifications and certification, and then limitations on their areas of practice. And then we have the rules of professional conduct, which are also Supreme Court rules. And what's unique about the rules of professional conduct, these rules are intended to regulate the conduct of attorneys, and they're enforced through discipline. So violations of rules of court may result in an attorney not being admitted to practice, or the Rule 9, Title IX rules also set forth procedures for obtaining review of decisions by the state bar. So a violation of some of those rules may mean the petition is not considered by the court. Violations of the rules of professional conduct will result in discipline, but that's not the sole source of disciplinary sanction. So violations also of the State Bar Act. So the State Bar Act will set forth duties and obligations for attorneys in the state, and violations of those provisions could result in discipline as well. So that's where both the legislature and the court will set standards in that area. So that's a brief overview. So what we're focused on right now are the rules of professional conduct for paraprofessionals. And again, as Fariba and Amos know, when we talk about standards that we want to impose upon paraprofessionals, the first question that I would probably have is, what is the consequence of a violation of that particular standard that you want to impose? And if it's discipline, it most likely needs to be in the rules of professional conduct. When we think about this process moving forward, once we make these recommendations, likely the first place we need to go is the legislature. The legislature will decide in the exercise of its police power what standards, duties, obligations they want to impose upon the program and upon the paraprofessionals that participate in the program. Then once those statutes are signed into law, then the court will go through its rulemaking process. So these rules that we're talking about now are recommendations for the court. Some of them may have to change based on what the legislature decides to do or decides not to do. And so we're probably anticipating, after statutes are signed into law, that we're going to have to reinitiate a rulemaking process. But what we're able to do here, I think, is sketch out the parameters of this program. And I think it's important for the court early on in the process, in order to endorse moving forward with the legislature, to have a clear understanding of what we're talking about in terms of what can these paraprofessionals do and what are the restrictions that they need to operate under, if that makes sense. Does that cover what you wanted me to cover, Leah? I think you're on mute.
Yes. Kim, that help?
Yeah, it helps a lot. So basically, the authority, though, for the paraprofessional program will come from the legislature. And then
usually so this is a good example of how it works. So the legislature, the mandatory continuing legal education statute, the way it's drafted is that the legislature asked the state bar to seek permission from the court to establish this program. And then they also set forth standards for the program. And so the state bar was then under legislative direction, they submitted rules to the court for approval, and the court actually adopted some additional standards. So again, the legislature can recommend minimum standards, but the court, they are minimum standards, and the court may adopt those as the only standards. But they can also adopt additional standards. What we're talking about doing, though, is standing up a new licensure program. So really, the court needs to authorize this because the court has exclusive authority over the practice of law. And so the first question I'm sure we will get from legislative staff is whether or not the court is behind this program. Will they provide authorization for paraprofessionals to practice? And then we go about the business of deciding exactly what they can do and what their duties and obligations will be, if that makes sense. But
Yeah, that's really helpful.
Yeah.
Okay.
Amos, I see you've got your hand. We're a small group, so maybe you don't need to use the hand raise.
Yeah, so I just wanted to follow up on what Greg says, because that is a very helpful overview, and I have learned a lot from Greg along the way. One additional thing that I think is helpful to keep in mind, as Greg points out, if we're proposing a regulation, his first question is, what's the consequence of violation? And if it's discipline, it goes in the rules of professional conduct. If it's not discipline, there's still a question, I think, of what we want, because there are limited consequences if it's in the rule of court too. And so some things might require statutory changes. And so Greg and others are keeping a list of possible legislation that we are going to try to propose or keep a list of. So for example, if an attorney violates the statute, requiring a written agreement or having something, or is a runner and capper, there might be criminal liability, there might be a voidable contract. I don't think we can get to those remedies in the rules of court or in the disciplinary rules. I think those kinds of remedies might require a statute. So at least we're going to keep tabs on a list of things. You know, an attorney-client privilege is something that is going to require a statute. So we're going to keep a list of proposed statutory changes as well.
Avoidable contract is an interesting question. I would be interested to hear what Andrew and Randy have to say on that at some point. But certainly we can't, through a rule of professional conduct, impose a criminal sanction. We can require through rules of court that attorneys engage in mandatory fee arbitration if it's demanded by their client, for instance. But the mandatory fee arbitration is a creature of statute. It was created originally by the legislature. So there is overlap there, I think.
Okay, with all that in mind, should we go back to our inventory?
Sure. And let me send this to you.
Oh yeah, I was wondering if you had done that.
Close it first. But I think our discussion with just Amos last time, we had left off on the informed consent rule, which is rule 1.4.2.
Yeah.
I don't know if you want to
Start
take
there.
up that discussion again, or because I'm not sure. Well, we certainly couldn't get consensus because it was only Amos on the call. So send it to you.
Yeah, I mean, I'll defer to Amos, Kim, and Freebet. Obviously, we need to circle back around on that issue, and we have till 2:30 today to do that. Before 2:30, I would also like to make sure we get through this whole inventory and kind of map out our next set of meetings. I don't care if we do it now or do it towards the end of our time today. It's totally up to you.
I had some thoughts about informed written consent. I don't know if anyone wants to hear them, but after our meeting last time, I was trying to come up in my head why articulate more clearly for myself why I was struggling with that concept during our conversation. But we don't have to start with my thoughts, as they might not be the most efficient way to get through the meeting. But when we get to that topic, I do have something to share.
So I'll just say I don't have a strong preference of how we proceed, but I do think that the practicing attorneys and paraprofessionals practicing together and sharing fees and referral fees, and maybe this informed consent requirement, have taken up quite a lot of our time, and there's a lot of things we haven't gotten to. So I'm happy to delve into those issues because I think they're important and maybe controversial. But I do think we need to move on to some of the other topics now that we have Fariba and Kim here as well.
I watched the recording and what a great meeting. I mean, I have like 10 pages of notes. So I'd like to a point of clarification. Our Kimberly and I, and Emma's going to be asked to come up with some sort of consensus on each of these issues. And if so, then I have some questions that I've come up with based on the recording. And I'd like to hear, I mean, we can start with informed consent because that was the last topic and it's fresher in my mind, personal preference. But I'd like to hear what Andrew had to say. And then if we have to kind of make a decision as to what the three of us think on those, what is our position, then that's what I'd like to do, is hear Andrew's comments, anybody else, and then have a discussion between the three of us as well.
Well, Leah can jump in and correct me if I'm wrong, but it's certainly my understanding that as a basic proposition, the whole point of the subcommittees is to put forth proposals. So I would hope that at least on the bulk of the issues, there could be some sort of a proposal put forward from the subcommittee to the group as a whole.
And in some instances, those subcommittee recommendations have not been consensus on other topic areas, right? There have been sort of a majority recommendation from a subcommittee and then dissenting recommendations. So I think ideally most of your recommendations would be consensus, and I think they will be, but they don't all have to be. So.
And I'll add, I think specifically for the rules of professional conduct, our goal is to have a draft set of rules for the June meeting that is pretty much a finalized proposed set of rules on all of these issues that we're in good shape. We're in pretty good shape on, but there's a lot of work still to be done.
Okay, so but it sounds like the request is to dive back into informed consent. So why don't we do that and then just make sure that whatever we do today, we leave 15 to 20 minutes at the end to map out our work plan. Kim, would it be helpful if someone, and I don't know who that would be, could be Amos, could be Greg, just gave a quick recap of where we are from that last meeting discussion? Would it be helpful to pop up on the screen the actual draft of the rule that we're talking about? Or should we just dive right into it?
So has there been a meeting between the April 27th meeting and today?
Just one. And
Okay.
only Amos attended. That's what, yeah. There was one and we spent almost the entire time talking about this issue and I don't know that we got very.
Actually, we talked mostly about referral fees, I think. This was just the final issue that we talked about.
Oh.
Yeah.
How could I forget?
So I do have the language in front of me, Leah, from the April 27th meeting. So I don't know if there was any changes at the subsequent reg subcommittee.
No.
No.
Okay, then I do have that. So you don't have to.
I'm happy to give a very brief overview and we can dig into the background if we want, but does that work?
Sure.
So informed consent is a concept that is in the rules of professional conduct. It's a defined term under Rule 1.0.1 E. And the Scuttles, no, not Scuttles, the ADLS working group went, in their proposals and of key issues for us to consider, did suggest that we consider an informed consent requirement. When Fariba and I were going through proposed regulation initially, we came up with a few high-level items that we thought would be very important for consumer protection, and we discussed and agreed on an informed consent requirement and tried to draft some language, which is now with some revisions in the draft rule 1.4. Is that 1.4.2? But the main idea is that as a consumer protection, as a new licensee where it's not exactly clear what the licensee can do and can't do, that it's important that there be an informed consent requirement, which would require the paraprofessional to provide sufficient information to the proposed client to know what the paraprofessional can and can't do, what the risks are, what the alternatives are. It is something that has been in our materials from the very early stages, has been in multiple reports, and has been discussed with the full working group. And so, the question I think has been raised, what disclosures, what information, and I think Fariba and I am interested, Fariba, especially if you heard the last recording, your feedback on this. But I think where we were going was we would like to make it as easy as possible for paraprofessionals to provide information that we think is going to be pretty consistent, maybe by practice group, that, that they're not an attorney, what the fees are, what the alternatives are. And if the more we can standardize it and make it easier for paraprofessionals, the better. But I think we've had some confusion and resistance of if it's just maybe it would be easier just to have some mandatory disclosures. We do have a separate mandatory disclosures requirement and written agreement requirement, which is now in sorry, I don't have that. A separate rule requiring a written agreement and written disclosures. And of course, some of the disclosures are overlapping, like they're not an attorney. But I think one of the issues is, do we need to revisit the informed consent requirement? Because the way it's drafted might lead to some confusion of, is it just a mandatory disclosure versus, can we make it clear this is an informed consent requirement, and at the same time provide supports for what clearly needs to be disclosed and help paraprofessionals with that discussion. And I think we've also agreed that it should be written or confirmed in writing, just as a best practice. Is that a fair overview? Please add or clarify.
And a separate writing from the written agreement.
Right.
Yeah. Yes. And so the questions that have been coming from staff, and I think that some of these questions were raised in the full working group meeting when we discussed this as well, and this is coming from me wearing my regulator's hat. I am wondering, reading this rule, what is the triggering event that requires the disclosures and the consent? Is it as soon as a prospective client walks in the door, they need to obtain this before they solicit any confidential information from the person? So for instance, disclose, I'm not a lawyer. There may be other alternatives. Here's a list of legal aid groups that you may be able to provide you assistance. Or are we asking the paraprofessional to gather what could potentially be confidential information from the prospective client in order to discharge the obligation to obtain informed consent as the term is defined under our rules? Because the term under our rules requires the paraprofessional to disclose all the relevant circumstances and the potential and actual consequences of the course of action. I'm going off memory. It's the relevant circumstances and the material risks, including actual and reasonably foreseeable adverse consequences of the proposed course of conduct, which to me has always meant the disclosures that you need to make in order to obtain informed consent has to be tailored to the person you're talking to. It has to be based on the circumstances. And so in order to know the circumstances, the paraprofessional is going to have to gather some information about the person. And in order to make some of the disclosures that are included in Rule 1.4.2 as it is now. The other question I had is, what are they consenting to, which is related to the triggering event. So are they consenting to moving forward beyond intake, or are they consenting to actual representation? And I think Amos's position is it's consenting to actual representation, which to me was a bit confusing because I thought that was the function of the written agreement. And I agree. I certainly agree. I'm sure the court agrees that there needs to be some mandatory disclosures of information to prospective clients as soon as possible, so that it protects the public from unwittingly engaging a paraprofessional who they might think is a lawyer or can do more than they anticipated or less than they anticipated, I should say. And that needs to happen probably early in the process, but it's difficult for me to see how that could happen early in the process the way the rule is written now.
So,
Right, and also,
Go ahead.
go ahead.
it's okay. Go, you want to finish, Amos?
Well, I was just going to say, I mean, I think, and Friba, please correct this if it's wrong, because I think it's based on our early conversations as well. I think we early came to the conclusion that it is important for consumers to understand what paraprofessionals can and can't do, and the risks and alternatives when making the decision, an informed decision of whether or not to hire the paraprofessional. So I think those early, very clear and very, I hope, non-controversial issues were really the heart of this, that, you know, a decision to hire a paraprofessional should be informed, and informed includes, you know, what a paraprofessional can and can't do should be clear, and, you know, that they're not an attorney should be clear, and that what the risks and alternatives. I think we've had some issues about what risks, what exactly do we mean by risks in this context? And again, I think our efforts have been, we want to try to standardize this and help paraprofessionals and as much as possible. But I've been very much resisting converting this just into a mandatory disclosures, that as long as they hand a piece of paper to the proposed client, that's sufficient, because informed consent is a concept that is throughout the rules of professional conduct, that makes sure clients and proposed clients have the information they need to make an informed decision, which I think is really at the heart of what I'm intending.
So I still agree. I haven't changed my position. I do have additional understanding of some information that I didn't have, and some understandings I didn't have when we had our discussion. And that's that there's really, I see three different documents here. One is, again, I learned this, you know, having listened to your conversation at the last meeting, is that there's some basic disclosures that have to be made, regardless of what the specialty of the paraprofessional is and what the facts of the case are. And those are, I think, what Greg called mandatory disclosures, sort of this basic disclosures that may have to be done at the get-go, like before the first conversation. And that could be something that's posted on their website, in any advertising material, and that's something that has to be mentioned again right at the get-go before the conversation starts. The problem becomes if the conversation is telephonic or remote in any way, how can they be done in writing, and you have proof that it was done, other than just the honor system, that is a rule and paraprofessionals have to follow it. I think that the informed consent as defined is just covering the risks and alternatives. That's later on, that's fact specific. I agree. It has to be done at some further stage after a basic interview is done. The paraprofessional knows what's happening, what the facts are, and of course the written agreement. I think that the mandatory disclosures, you know, it's really necessary based on, again, we've talked about this before, because the clients are then put in a position after having spent some time and invested some time with the paraprofessional, that they may, you know, go ahead and sign anyway. If at the last minute the paraprofessional said, "Oh, by the way, you know, I'm not an attorney, and here are the risks. Here's all this other content that is the mandatory disclosure," versus if they're told ahead of time, like at the get-go, they may be in a better position to, you know, stop the call. "Oh, I thought I was calling an attorney," you know, and I wasn't aware about your limitations or something like that. So I think I think I like having those sort of delineated separate stages. And I would not necessarily mind that the mandatory disclosure is not in writing and signed by the client, but it's got to be somehow posted in any advertising materials on their website, and definitely a rule that they have to say certain things at the start of the conversation. So that's where I stand. And by the way, I'm just really bothered by the details of the alternatives that I heard you'd like to be listed. I just think it's so onerous for a paraprofessional to have to find out the various legal alternatives in that, legal services alternatives in their area. I think that a more general statement would be appropriate and not as onerous.
Fariba, could you clarify a little bit more what you see? One of the things I was struggling with is what is the distinction between the content of the mandatory disclosure and the content of the informed consent? Where I came to was what I think you mentioned, the informed consent is more case specific, fact specific. The way it's used in the current context, it would be about something like, I'm the client and I want to choose this litigation strategy, and my attorney's telling me that's not a great strategy, and I'm telling you why, but you are, I don't know, something about like consent to proceed or not proceed in a certain way, fact specific. Mm-hmm. That is really different than the kind of informed consent that you and Amos have been talking about, which is more like consent to work with a paraprofessional, knowing the risks involved. That those risks, to me, is what are delineated in the mandatory disclosures. The risks being, I can't represent you in a jury trial, for example. If it's this case type, I can't do X, Y, and Z. If it's this case type, I can't. So what do you see as the difference in content between the mandatory disclosure and the informed consent? That's what I'm struggling
with. So actually, I wrote down some notes on that. I think that an informed consent is more affirmative on the part of the client, that I know, understanding all the limitations and the role of this person, I am agreeing to hire them. But in my opinion, the mandatory disclosures are more passive. It's just information that the paraprofessional provides, doesn't require any special kind of action by the client or a signature by the client, other than allowing the client to go forward if they want with the rest of the conversation or not.
So let me just add, I think that's a very good way to think about it. But again, I think what an informed consent means is not something we're creating here. It's a well-established principle that is throughout the rules of professional conduct. And the idea is the client needs to be given reasonable and sufficient information to make an informed choice. And I think some of the concerns and confusion that have been raised is mandatory disclosures, a form doesn't necessarily get you there. And so it's really a different concept. Mandatory disclosures or a standard set of disclosures is important and can be helpful, but it isn't necessarily sufficient because to satisfy the ethical obligation of getting a client's informed consent. So I do think that what you just described, Fariba, is a good way to think about it, that mandatory disclosures is sort of a form you can pull off a shelf, and you could say you provided the disclosures and can show the form. But in none of the, I don't know, probably more than a dozen places where informed consent appears in the rules of professional conduct, I don't think any ethics expert or discipline tribunal would say just pulling a form off the shelf isn't necessarily sufficient to show that the client had given informed consent.
I think we're saying the same thing, but maybe that's
I agree. I just wanted to clarify.
Okay.
I think there's just from prior discussions, I think there's just a fundamental misunderstanding of the difference between mandatory disclosures and informed consent. So I'm just clarifying that Because again, I think part of the confusion is, Fariba, when we drafted our proposed informed consent rule, it included a list of mandatory disclosures. And I felt like this, we've tried to go back and forth. Maybe this should just be a mandatory disclosure requirement rather than an informed consent. So I'm just, again, teeing that up, that that's not, that what we are talking about is an informed consent requirement.
And I know Kimberly wants to talk to it. Just one more point, Leah. And the mandatory disclosures should not be specific to the practice area. Like, I can't represent you at a trial. That should be left for informed consent, because depending on the subspecialty, the in-court representation levels may be different. You see, because the default is full in-court representation, but each subcommittee is going to come up with their own plan and proposal and may opt out of full court representation. So mandatory disclosure should be as basic as possible. That would apply regarding the specialty. Things like, hey, I'm not a lawyer, for example.
Okay. Did you want to say something, Kim?
Yeah, so Fariba, based on what you said, are you thinking like the mandatory disclosure would be different for each different paraprofessional based on what area they're practicing in?
No, what I'm saying is that it should be basic statements that apply to every paraprofessional regarding of the area of specialty, like I'm not a lawyer.
So some of those high level things.
Mm-hmm.
I mean, it almost sounds like from what Amos, you were saying, like, and maybe this isn't it, but you know, you have this mandatory disclosure, and I think mandatory disclosure should be as much in there as you want that person to know about. And then your informed consent is that I've reviewed the mandatory disclosures, I've read them, I understand them, and now I'm consenting to accepting these, you know, all of these things in the mandatory disclosure and willing to accept you and I'll be your client. Is that, maybe that's the difference that I kind of see.
So I think we could possibly get there. Again, I think Fariba broke it down into 3 different writings, and right now our draft is 2 different writings. I'm concerned about over-regulation and making it too burdensome with having 3, but we could talk about that. But I think for me, what distinguishes the informed consent requirement and what disclosures might be made in that from what we currently have as the written agreement and mandatory disclosures as a separate requirement is really about the risks and alternatives. Because I think the mandatory disclosures currently list, like, I'm not an attorney, here are the fees, this is, you know, what I can do, this is what I plan to do. Where we don't have in the written disclosures the things about the risks and alternatives to get consent, to make sure that it's an informed consent, that they, you know, is a free attorney available from the local legal aid? Is there a low cost flat fee attorney that's available? Is this likely going to require a trial and you can't help me in a trial? Those kinds of decisions, informing the proposed client about these kinds of things. I think the resistance here, the problem here is, I don't think we can standardize a form that has that.
Well, my question is also how, because it's not going to, the answer is not going to be the same across the state. You know, it may not be the same across contiguous counties, let alone across the state. How is the paraprofessional supposed to garner all that information? Like whether, I mean, I don't think a paraprofessional could represent whether there's necessarily a free attorney available. Like what if they think, so what if the paraprofessional contacted the local agency and they said there's someone, and they put in the form there's someone available, and then the person goes there and is told, no, there's not anyone available. I think there's a limit to what we can possibly expect them to be able to get and represent.
Absolutely.
And how would a disciplinary tribunal evaluate that after the fact? I mean, there's
Right.
2 questions to Justice Petron's question.
I think that's exactly right. And I think that's
very
the
difficult.
answer. Oh, sorry. Go ahead, Andrew.
Sorry, I'm just saying it would be very difficult.
I 100% agree. And I think that answers Kim's question. And I agree with you, Justice Patru, that the informed consent that is required. And I think Fariba and I were discussing, hey, try to simplify it, try to standardize it, try to create some forms that'll help. But that looks very different from what we currently have as our written agreement mandatory disclosures, which don't have that kind of information. So,
Well,
we should discuss what would be sufficient, but certainly what we currently have in our written disclosure rule is not sufficient to get informed consent.
I think we should actually look at the rule and start going through the rule provision by provision. And because I think we can kind of chase our tail a bit around on this. My concern continues to be, as written, based on the requirement, is that we're going to have situations where somebody goes to see a paraprofessional for legal services. When they walk through the door, they're not obligated to say they're not a lawyer right away. They're under the rules right now. They could sit down and say, tell me what your problem is. Okay, gather some documents, bring them back to me. I'll look through the documents and see if I can help you. Okay, I can help you. I have a good sense of how much it's going to cost right now. But first, to engage me. So this may go over 2 meetings or 3 meetings where they're divulging all this confidential information to this person, and the prospective client is investing their time. And it's only at that point, the triggering event is, okay, I think I can help you now. But first, I need to make some mandatory disclosures and get your informed consent to proceed. Here it is. I'm not a lawyer. Oh, you're not a lawyer. Oh, and by the way, you may have to get a lawyer at some point. Oh, and by the way, there may be some free legal services available to you. I don't think that's protecting the public at this point. That's the concern that I have. And that's why triggering event is really stuck in my mind right now, because in order to protect the public, we need to give them this information as early in the process as possible. And
Nothing you said, Greg, couldn't be a mandatory disclosure.
it could be a mandatory.
I'm not an attorney. There may be free legal services available to you or low cost legal services available to you. That's, again, I'm a broken record, but like a lot of that could just be put into the mandatory disclosures. Before we look at the rule, Andrew,
Let's look at the rule.
You wanted to say something.
Could I just jump in and say, I don't know if any of you have seen Judicial Council Form FL 940. That's Office of the Family Law Facilitator Disclosure. Is not mandatory for use, is optional, but it could help you kind of see what basic statements are there that apply to every family law facilitator office, including that the fact you should consult with your own attorney if you want personalized service strategy to have, because we cannot give you legal advice. This is not a confidential communication. It has very basic information that applies to every family law facilitator. And that's what I'm talking about. And we can we have to post it. They don't have to sign it for every interaction that we have, but there are signatures present. We do it for every stipulation that we do here in my office, but every office is run independently and they do things differently. But this is a really good example of what I'm talking about.
So I agree. I think having a mandatory disclosure earlier in the process with some standardized disclosures could be very helpful in protecting the public. And I think it's consistent with what we do in other spaces. I think immigration consultants have to post something on their wall and, this sort of thing. But again, I think, and Fariba, I would like you to confirm that that doesn't take the place of what we're talking about as informed consent. So that is a separate additional protection for consumers, which I don't have a problem with. I think it would be helpful. Now I'm worried that we're going to be over-regulating. I don't think we can get out of the need for an informed consent requirement, that consumers who are thinking about hiring an attorney, a paraprofessional, need to be informed about the risks and alternatives. And that, I don't think that can be done.
Writings is to include it in the written agreement itself, because the written agreement is the consent to representation. So
I was just going to say the same thing, Greg. That I was thinking that sounds like Amos, if that's the big concern, like before they actually enter in, that sounds like something that should go in that written agreement in the other rule, that they're agreeing to it.
Okay, so again, we've talked about this many hours, so I don't want to belabor the point, although Kim, you weren't part of those discussions. But if we are going to combine the informed consent requirement with the written agreement, which we've worked very hard to not do, and we've had hours of conversation about why they're separate and why they need to be separate, we're going to have to majorly modify the written agreement proposed rule to include informed consent disclosures and language. And again, that includes risks and alternatives and clarifying what a paraprofessional can and can't do. That's currently not in the written disclosures rule.
So, it could be.
Specialty.
And let's let Andrew jump in because I know you've been saying you had some ideas to share. Go ahead, Andrew.
So, I mean, at the heart of this, we're struggling over the semantics of informed consent and written disclosure. I think that's what we really are. And as I ended the meeting last time, I appreciate and respect where Amos is coming from. And I know Amos says several times an informed written consent is a concept in the rules of professional conduct is understood. And that's true. It's a concept in the rules of professional conduct. However, and further disclaimer, I'm just a staff person. You can do whatever you want. It's going to be the court's decision. I don't vote in these things, but I do know rules and ethics somewhat well. And my concern is informed written consent is in the rules of professional conduct, but its function is to operate as an exception to the otherwise rules prohibitions. Okay, so you can't engage in representation in which there's a significant risk that the representation will be materially limited unless you get the informed written consent of the client under 1.7. You can't be adverse to a former client in the case in which you have confidential information about that former client unless you get the informed written consent under 1.9. Can't enter into a business transaction with a client unless you enter an informed written consent under 1.8.1. There are all these concepts, and they're all exceptions to general prohibitions. And so for me, what we're talking about here is you want, if I understand Amos correctly, you want to require informed written consent to enter into a representation with a paraprofessional. And so for me, in order to be intellectually consistent, you'd have to be suggesting that such a relationship is generally prohibited, which can't be the case because here you are setting up a regulatory structure which requires education and training requirements in order for those people to perform services as paraprofessionals. So what it comes down to is there are essential public protection elements that all of you are talking about, and they are understandable and agreeable. And I think any objective person would agree with them, but they are at the heart simply disclosures. You are disclosing, I'm not a lawyer. You're disclosing if you want, however onerous you want to make it. And I would also like to just share the Rules Revision Commission was under the instruction that rules of professional conduct are to operate as minimum standards for discipline. They're not supposed to be best practices. They're not aspirational goals. And so I think we should keep that in mind when we're talking about 2-3 different types of disclosures at various points in the representation. That does get quite onerous. Or telling the client why they should hire someone else instead of me, a properly licensed paraprofessional. That really, for me, just personally, that becomes concerning. So all that to say, we could so simplify this if there could be agreement be reached. And you can beef up the mandatory disclosures as much as you'd like, but that's really what it is, because informed written consent requires more information. It requires specificity for the case. And if we're going to be consistent with how informed written consent is known and understood in attorney ethics, you would have to be suggesting that it's an exception to a general prohibition, which I just intellectually, I don't think that that's the case here.
So that is very helpful.
Sorry for getting animated.
That is very helpful to understand where the resistance and confusion comes from. But let me engage with you just briefly on this, and I think it's worth a conversation, because I think what I mean by informed written consent doesn't cause the confusion or inconsistencies that you're experiencing, and I think it's clear that and maybe informed written consent can be supplemented or clarified, because I think what I mean from an ethics point of view is consistent with Rule 1.4 A and B, which is communication that explains the matter to the extent reasonably necessary to permit the client to make an informed decision. And I think that is consistent with other rules that use informed written consent, including Rule 1.7a, needing informed written consent for conflicts, Rule 1.8.1, requiring informed written consent for business transactions with clients, Rule 1.8.2, informed written consent to use clients' information, Rule 1.8.7, informed written consent to do aggregate settlements. And the idea is, these are things that attorneys can do, clients can do. It's just that an attorney needs to provide sufficient information for the client, including risks, and in this case, it would be alternatives, to allow the clients or prospective clients to make informed decisions. And again, mandatory disclosures are helpful for that, but not necessarily sufficient.
I actually understand Andrew's comment differently in that the list you just gave, Amos, for example, conflict of interest or enter business transaction, they're prohibited unless the client consents. What Andrew, correct me if I'm wrong, what you're saying is a paraprofessional representing a client is not, there's nothing prohibited here.
Exactly.
That the client consenting to. It's just we want the client to have notice of who they're talking to, what their limitations are, an opportunity to not hire them, and say, oh, okay, you're not an attorney. I thought you were an attorney. I'm going to go hire an attorney. Or you can't represent me at trial. I really should hire the same person to represent me throughout. So my cost is an increase, something like that. Am I getting this correctly, Andrew? Is that what you were saying?
Yes, and I should have said also in my commentary, I thought Kim in her comment earlier nailed it on the head. If you want to, or offered a helpful solution, if you want to have these mandatory written disclosures and have the client have a chance to review it and then consent in writing after receiving it, I think we're serving the same purpose that we're all talking about. And I don't mean to get hung up on the term informed written consent, but it is a different function under the definition of the rules for attorneys. And if we incorporate it to operate in this client protective at the outset function for paraprofessionals, I don't know, I'm not trying to be overly sensitive to it, but I do think that there is a distinction there. And I think it also, I'm trying to simplify the process. And again, it can be as robust as you'd like it. And maybe we should start going through the provisions as Greg has suggested, but give that to the client, not make it simple, like just put your initials, we're going to move it on. It could be a separate document, maybe give the client time to consider it before signing. And I think there's protection there. And, if harm results, you can always revise rules downstream, but if you're going to try to comport these rules to those of attorney standards, we might have to have a justification for why there's this additional requirement in this setting. And we could probably come up with that, but I just think you want to keep that in mind as you go to the court. You'll want to describe why, it's a different requirement here than for attorneys.
Is this the rule? What I have on the screen is the right rule, what we want to talk about, 1.4.2, looking at the elements. So
I think so.
This is currently what we have as the written disclosures. This is what you wanted to go through, Greg, like item by item.
I think it would be helpful to actually start looking at it specifically, what we're talking about, since we have to approve a rule.
And Leah, just real quick, just from experience, when I was at the medical board, we had licensed midwives under under the medical board, but they didn't have to be supervised by a physician, and it was a law that was changed. And what you're saying, it's funny because I'm like, how's this ringing a bell? And I went back and pulled up that section of the BMP, and they have something very similar in 2508 of the Business and Professions Code, and it's very, very similar to what you guys have here. And it's kind of the same thing, because you know, you wanted them to know this isn't like a physician and how they interact with each other and what's required of them. And they actually have very similar, that you're disclosing this, but then that individual also has to obtain informed consent, that they're consenting to, you know, basically that you do have to go see a physician under certain requirements and everything. So there is some, I don't know if Amos, if that's kind of what you're thinking of, is that, you know, your informed consent is I'm agreeing to all of these things that you're disclosing to me.
Yeah, absolutely. It's very consistent. Again, I think it's consistent with all the other places in the rules of professional conduct for lawyers where informed consent is required, but it's certainly consistent with the medical profession where a doctor has to get informed consent to do a procedure. The idea is if they just said, here's a list of disclosures, that's not informed written consent by any means. So they're different concepts.
No, but if you look at 2508, it is more what you were talking about initially, Kim. The informed consent is based on a review of the disclosures. It's not something, so the informed consent codifies or captures or reflects the fact that you understand what was disclosed to you. That is different than what you're talking about, Amos, I think. And I think you keep saying it's consistent with the way informed consent is used in the attorney rules, but you have kind of staff that's really expert in the rules telling you otherwise. So I'm kind of struggling with that cognitive disconnect. I think we're hearing in the attorney rules, it's an exception. It's used to accept something that is otherwise prohibited. And that is not what we're talking about here.
So it is. I just think, as Andrew says, it's semantics, because a paraprofessional would not be able to enter an engagement with a client unless they got informed consent. That is how this draft rule is written, and that's not inconsistent in any way with other means that prohibit conduct unless you get informed written consent. And
Isn't that kind of, sorry.
No, go ahead.
I'm not trying to be difficult or slow. I just get stuck on that, because here you come up with a licensing program, whatever, and I know there are other subcommittees working on this. You have the educational and experiential requirements. You pass an exam, whatever it takes. Here's your paraprofessional card, like, you know, compared to a bar card. You're able to provide services. I mean, that's, yes, you have to enter into, you know, retention agreements, but then I'm just stuck on that the intellectual disconnect there of then saying only if someone agrees to entering into retaining you after all these further disclosures. I just can't think of any other professional where that's required.
But I assume fundamentally you don't have an objection to the concept that prospective clients need to be reasonably informed about the risks and alternatives, and to have enough information to make an informed decision of whether to hire a paraprofessional. All right. So it really is just.
Amos, this is you know, I just jump in for a second, and I apologize because about, I don't know, 20 minutes ago, I had to step off for an urgent call for a few minutes, but I'm still struggling with understanding. I would just like to understand what you mean by them being informed about reasonable alternatives, because I just don't see how we're doing that piece of it.
So that is a very helpful comment, because that, I think, drives the point home that a written disclosure that says I'm not an attorney is not sufficient to inform the clients about the risks and alternatives. Now, what we require about disclosure of risks and alternatives is a separate question, but I think the fundamental question that is being teed up now is, are prospective clients going to be required to, you know, be provided information to allow them to make an informed decision? And again, I'm just assuming that the resistance isn't no, prospective clients are not going to be provided the opportunity to make an informed decision. It's a semantics question, which is, you know, where should the rule go? What should the language be? What should the requirements be? I think very strongly and fundamentally that prospective clients need to be told what paraprofessionals can and can't do, and need to be informed of, the risks. What are the risks? I mean, again, we can decide what that disclosure should look like and what it should say. But I think what's being proposed now is to eliminate the informed consent requirement, which I have a very, very fundamental problem with.
That, I don't think that's what the recommendation is.
Okay,
I
if
think
it's semantics about where it goes, I don't care. But I think fundamentally, there needs to be an informed consent of prospective clients that are provided sufficient information to make an informed decision.
And I don't think there's any objection to that. I think what we're struggling with is making a vague rule that is unenforceable. That's what we're struggling with. That's why I really want to dig into the actual rule language at this point, because as Justice said, we're asking you to identify what those risks are in a way that a paraprofessional can discharge their obligation under the rule.
Totally agree.
Yeah,
Totally agree. So I would like to work
right
on
now,
what the
what
risks
exactly
are, and standardizing it. I think we should identify what the risks are and standardize it, help paraprofessionals. But I think that's not what we're discussing. What we're discussing, because that's the definition of informed consent, is providing the client or prospective client information about the risks. What are the risks? We need to talk about that, but we can't. I think it's a fundamental mistake to say prospective clients shouldn't be informed sufficient to make an informed decision, because that is the basic.
Saying that.
Nobody's
It's
saying
really
that.
just about where it goes. Where is the information relayed? I think it's probably not totally productive to keep characterizing it as resistance to the idea of informed consent. It's just like not understanding your proposed approach. But let's say, Greg, if we just start with one, this is under mandatory disclosures 1.4.2. So the first one up. Yeah.
I'm sorry, could we go up higher? Because
Yeah.
I do actually agree with Greg as far as where the timing of this is. I go to not to the one, to A, basically, in 1.4.2. Sorry, Greg.
Oh, A. Okay.
A. Because I do think it needs to kind of be clear, before any advice or before anything is given, because to Amos's point, right out of the gate, they need to know that this is not, you're not talking to an attorney, and it is going to be different what you can get from this individual versus what you would be able to get from an attorney. So I think that's important for them to know right up front.
So I'm going to recommend, and this is consistent with Fariba said as well, that there be a separate mandatory disclosures that's triggered earlier. I don't think we can have as Greg explained, I don't think we can move the informed consent to the beginning, because informed consent needs to have additional information. So I think what you're saying and what Fariba you're saying is you would like to see an initial triggering event that triggers a certain number of mandatory disclosures. And I think that needs to be separate from the informed consent concept.
So I'd just like to clarify that based on what Andrew said, I just think we were looking at the informed consent document the wrong way. At least that's my position right now. I'd like to just stick with one document, mandatory disclosures. Again, I pointed out FL-940, something similar to that with more statements in there. But I just don't think we're talking about the same things here. Informed consent for attorneys is something totally different. I think that it's just a contract to enter a attorney or a paraprofessional client relationship. Having received the disclosures is sufficient for me at this point.
And
given at the outset, like the outset of the relationship, so they, the client is aware who they're talking to, what their limitations are, and can make an informed decision before signing that written contract.
Maybe just to try to offer help to proceed. If Greg, if you just want to highlight the first sentence of A.
I think Leah's actually.
Yeah.
Oh, Leah. And
This-
just shade it in blue. We'll come back to it. That's where we're talking about what it is. And I think Greg's point from a good 30 minutes ago, let's go through the list. I think it'll help us make some progress, and we can come back to what the
So-
group thinks
So
it should
when we
be
go
best
through this
characterized.
list, is this, we're presuming that these are disclosures that need to be made prior to obtaining consent to continuing near the beginning of the relationship, obviously prior to representation, because the part that's blue, can you just go up just a little bit? Informed consent to representation. It's the to representation part that's I'm getting stuck on, because consent to representation sounds like a written agreement to me. I don't want this to be interpreted that once a client signs this informed consent to proceed, that somehow a paraprofessional client relationship has begun, because that's not my understanding of what we're trying to do here. I think what we're trying to do is make some disclosures to a prospective client so that they can make an informed decision on whether to proceed.
So
Okay.
I disagree.
So should that be under Rule 1.18?
Well, Greg, I think you suggested we go through the elements, so let's do that, because I
Yeah,
think
let's
you
do that.
inadvertently took us away from that just
The
now.
only reason I bring that up is because the elements may change depending on what we're consenting to.
I definitely agree. And
Yeah.
so that's why I think your point is clear, and then we can just go through these. But this
Okay.
was drafted as informed consent to the representation. And I think what you're
Well,
talking now is a different, it's not informed consent, it's mandatory disclosures at the initial, triggered by the initial phase. So I suggest you separate that. And again, you can change this rule into it, but not eliminate the informed consent requirement, because I think there needs to be informed consent to enter into the representation. And I think you're proposing something different.
I am because of the confusion that I'm talking about in terms of creating a relationship. The original rule that you had provided, Amos, stated that this needed to be done prior to the performances of services for a fee. And it said the client must, the paraprofessional must give the client as much information the client needs to make an informed decision. But it doesn't say anything about consent to representation. That came later after when I asked you that question, and it's reflected here. But to the extent that it's consent to representation, now we're talking about something that the prospective client is signing well into the process after they've already gone through much conversation and disclosed a lot of information to the person. So that's why it's reflected this way. So let's go through these. One is pretty uncontroversial, a statement that the licensed paraprofessional is not a lawyer. The second one, reasonable disclosure of the possibility that there may be alternative choices, including availability of a lawyer as an alternative, the availability of a free consultation with a lawyer, the availability of limited scope services from a lawyer, and the possibility of free,
Yeah, sorry, I tried to make it bigger and I made it smaller, sorry. All right.
the free legal service that may be available if the client qualifies. So this is a pretty, I mean, I probably would want to wordsmith this a bit, but this is a standard disclosure that these things may be available. We don't know what the circumstances of the particular client is, but this has been changed so that it could be standardized in some way. Does anyone have any comment on that?
I have problem with reasonable just as a regulator. If I was gonna try what is reasonable in whose opinion, I think that document, that word should be just taken out and it would be disclosure of, but reasonable really causes me concern when I'm trying to regulate.
Yeah, the reason there's an asterisk there is that is a defined term under the rules of professional conduct, reasonable.
Oh, okay.
Yeah, and let me. So I have
It's
But
funny, I was wondering what the
if-
asterisks were.
Wait, if the language is this generic, right? why does it need to be modified by reasonable?
So reasonable is to, just so everyone knows, reasonable is defined as reasonable or reasonably when used in relation to the conduct of the licensed paraprofessional means the conduct of a reasonably prudent and competent licensed paraprofessional.
So then you'd have to have an expert to define that.
Yeah.
But I guess what I'm saying is, why wouldn't we just require that the paraprofessional disclose the possibility that there might be available alternative choices? Why does it need a reasonableness element?
I agree at the beginning, before there's any conversation and no details about the client. So again, if we're changing this to just mandatory disclosures, I think they should be standardized, completely standardized as much as possible. And this is not going to necessarily provide information for the consumer to actually make an informed choice about the representation, but just some initial disclosures that everyone should make. And it doesn't need to be this much detail.
Right, and I'm just wondering if we could make, stop, not have the examples that we have in there right now, and just have something like available alternative choices for legal services and representation, something to that effect.
The disclosures, without the possibility that there might be, if you just say disclosure of available alternative choices, you are imposing that obligation upon the paraprofessional to know what all the available choices might be, which they may or may not be. It seems overly burdensome. I'm not sure that they would know what the available choices are. So
How could we word this that it just imposes the general obligation to say, by the way, there may be available other alternatives you have for what you want to get done.
Right. And the maybe part is what's captured with the possibility that there might be.
Okay.
Maybe.
But do you need the including part? Do you
No,
need
but that was
specific...
part of the original rule that Amos had recommended. This is lifted directly from that proposed rule.
So I just think there's some confusion here, and I'm very uncomfortable with this conversation, because again, we've had hours and hours of discussion, and I think all of a sudden we're completely fundamentally changing this sort of basic procedural requirement that we agreed was sort of, we've really stood up this program, at least from the regulation committee standpoint. This prior, informing potential consumers about what paraprofessionals can and can't do and the risks and alternatives, and getting informed consent is sort of a fundamental protection that we previously agreed to. And what we're doing right now is just walking through it and watering it down and changing it from an informed consent requirement before representation to an initial standardized disclosures. And I'm really uncomfortable with this. I'd like to have more conversations with it. And we have so many other rules that we haven't talked about. I'm really uncomfortable just walking through this without more of that background, and sort of, in my opinion, we've sort of stood up the work of the regulation subcommittee, assuming that we had agreement that there would be an informed consent requirement prior to representation, where consumers would be told, would be informed about the risks and alternatives.
I'm really struggling to understand what you think we're doing that's different than that. And I would just say, because I think you're sort of the lone voice really struggling with what we're doing, that maybe we could continue going through this list and then perhaps talk about what would be additional or different in a separate informed consent. At least that would help me. Right now, this is mandatory disclosures. What would be distinct, new, different, enhanced, something else if we were talking about informed consent? But at least let's go through the list.
I think that would be I'm 100% on board with that. What I would recommend to be able to do that is to leave this rule as it is and copy and paste it to another rule, because now we're not doing we already have this draft rule that we've been comfortable with, that have been in the last 4 or 5 drafts. And now we're coming up with a new, different mandatory disclosures at the initial meeting, which I think is fine if you want to do that, and you want to use this list to inform that discussion. But if I say leave this rule as it is and then copy and paste this to a new rule that you can say initial mandatory disclosures, and we can go through that.
For my part, I just want to mention, Amos, that I'm not changing my mind that consumer protection is needed, but how many hours of meetings have we had? And I've become a little more educated each time, including the last meeting. So I don't know if I'm changing my mind regarding the concept of the providing consumer protection. I'm changing the way we're going to provide it, just for my part.
I have no problem with that. So I think what Leah is proposing is right. Let's leave this rule as it is. We can come back and revisit it if we want to, but now we're talking about creating a new mandatory disclosures at an earlier trigger point, and we're going to run through these to see what that looks like. We may end up deleting this if people think an informed consent requirement prior to representation is no longer a good idea, but I don't feel comfortable revising this rule right now by creating, and in its place, creating just a mandatory disclosures at the very initiation without any information about, alternatives and risks.
Well, I'm not on the subcommittee, but I suggest in override of Amos's objection and that we keep going through this list, because I think it's not totally making sense to me. And I feel like if we just keep going through it, we'll see what we've covered so far, regardless of the vehicle that we're talking about.
And I'm in agreement with that, Leah. Just to be clear, I'm in agreement. Let's go through the list. But instead of editing this proposed rule that we have the draft of, if you don't mind, please copy and paste this into a new rule, and we can go through it and change it in that new rule.
Okay, so what I'm doing here, just for my own ease of what I'm doing, I have a totally different screen up where I'm actually taking notes. So if it's just helpful for me to leave up on the screen what I have, not copy and paste and create a new document. I've got another document going on a different screen. I'm taking notes. So what I understand for Reba to be asking for is 2 to be revised to make it simpler. I just made a note to that effect in a separate document. And maybe I think the point of 2 is it's the requirement that there be a disclosure that there are alternative choices available. Right now, it delineates those choices to some extent. Reba was asking for a more simplified version. Maybe we can go to 3 now and just understanding what 3 says. Is that okay?
Leah, can I just say though, if this is at the beginning, if you're looking at the, disclosures up front, it might be good for them to know, like, and I know for simpler, I agree with Reba, but it's nice to have simplification, but I do wonder if they need to know what some of those options are. And I guess I'd look to Andrew and those that would have to push this forward if they didn't say, oh, by the way, you do have the opportunity for free consultation, because that's where I guess it comes in. I don't know if you're going to miss something because there's other alternatives probably. I don't know if it's good to take everything out of there at the upfront. If you're trying to give disclosures to the individual so they know what's out there and available. I don't know, Fariba, how you feel about that.
I actually don't see why we want to saddle paraprofessionals up with that responsibility, other than telling the clients that there are other alternatives and leaving it to them to choose to stay with this person or go with the other alternatives. In my office, I have a list of resources. Not all family law facilities have that. And I have to tell you, I have to update it several times a year because these agencies come and go, funding changes. Now they're representing these people because of this grant, but then later on they're not. So, and I would hate to do, to provide old information and just, bounce clients here and there. Which causes frustration. That's what I'm thinking. Also, I think it's more enforceable, and you can correct me if I'm wrong, Greg, that to not have examples, just the obligation of informing the client that there are other alternatives.
Okay, I'm okay with it.
Yeah.
I'm good. Yeah, that makes sense.
And I think for right now, because I don't think Amos is going to agree to that, well, I'm just making a note, like Fariba and Kim, okay with more simplified language, but then let's move on to 3, because it may be that you aren't going to agree. We're going to have 2 different versions that go forward. But if we could just move on to 3. Because I think
just
3
to be
is
clear,
a
I
bit
do agree.
doozy.
Just to be clear, I do agree for at least the initial contact, that it should be very simplified and standardized, I think.
Okay.
Just
Okay.
a wording change. I think the availability of limited scope services should be limited scope representation. That's how it's used in the rules of professional conduct. I think it means the same thing. I hope it's viewed as a friendly amendment from a lawyer. Limited scope services, I don't think that's the technical term. I think it should be representation.
Okay, but what people are talking about now is getting rid of all this.
Oh, okay, cool. Never mind. Sorry, I missed that.
Um,
Apologize.
all right. 3.
The risk of agreeing to obtaining legal services from a licensed paraprofessional in language that the client can understand. And Kevin has a comment there, including but not limited to, as if.
Yeah, I think you need to
wants us
describe the
actually
risks.
List,
Yeah.
identify what those risks are, which is, I think, a
Exactly.
question that Justice Petrillo.
Are we really talking about risks or limitations?
This was a question I actually had at the full working group when this came up, is this section, because the risks, what kind of risks, what are those? So I was struggling even at that working group on this part. So I'd love to hear the thought of what those risks would look like.
So I can tell you, because when we drafted this initially, the idea was very basic, that I already explained, that before entering into a retention agreement, that the client needs to know what the paraprofessional can and can't do and what the risks and alternatives are. And so we kind of put a hold on this because at the time the practice areas hadn't yet decided what paraprofessionals can and can't do. But I think at least before, we were on the same board that we wanted it to make sure that the clients were informed about the limitations of the license, and before entering into the agreement, to be able to make the informed choice of, does this make sense, or am I better off getting an attorney, or free service, a low cost flat fee, or whatever else is available. So all of this, I think we want to make it easier to explain in standardized language. But if it's a standardized form at the beginning, I think it's going to be very limited and very limited in usefulness.
But so if it wasn't standardized, let's say it's housing or family law, what are, like, if you were going to be very specific about the risks, what are the risks?
In housing, I think the risk is that it's going to require a trial, and the paraprofessional is not licensed to handle the trial.
Mm-hmm.
That could all, I'm just saying that risk has such a negative connotation to it. Don't hire me, it's risky. No, if you want to hire me, you have to understand that for UD, I cannot represent you at trial. That's a limitation. And I think that's a more positive connotation than risks. And I agree with you, Amos, about our conversations and why we wanted to include this. I'm just suggesting that we replace the word risk with limitations, because that's what you just said yourself too, that there are limitations.
Yeah, I don't mind for the initial, again, for the informed consent, risks is in the definition of informed consent. That's part of what you need, is to disclose risks. But yeah, if we're creating a standardized form, we can use whatever language we want.
So it sounds like one risk that we've identified are the limitations on the legal services that the licensed paraprofessional can provide. And another one is, it's the next one, actually, the potential need to hire a lawyer if the needed services go beyond the scope of the license. Are there
Exactly.
any other risks that we need to, that you would like to disclose to a prospective client?
I think they're covered in the other one.
Yeah.
Okay.
Okay. Now, so the potential need we just talked about, that's another risk. The existence of financial arrangements such as referral fees or fee sharing that a paraprofessional has with others. This is something that would be part of the informed consent. I'm not sure it could be part of something that would be a standardized disclosure at the initiation of the relationship.
I agree. I agree with that as well.
Yeah, me too.
And also this number 6, the reasonable estimate of total cost of services, which of course is something that's also in the written agreement itself. And this, to me, obviously would not be something at the beginning of the relationship they would necessarily be able to disclose.
I agree with that as well.
Agree.
Do they need to disclose their rates at all? Not the total cost of services, but, or is that for the written agreement?
I mean, again, it should be part of the informed consent, but why would we require that at the very initial conversation? That's a very limited disclosure.
I also think it's going to be difficult for paraprofessionals that have a flat fees for some things and then hourly fees for others. So I would rather leave that off.
Okay.
I agree.
The next one has to do with whether or not they carry professional liability insurance at the time of the engagement of the licensed paraprofessional. To make this most useful, obviously, it would be probably a disclosure that you'd want to coincide closely with the written agreement. If you require them to disclose whether or not they have professional liability insurance at their first conversation, there is the possibility that would have lapsed. So I think it's something you may want to, they shouldn't, you may want to obligate them to disclose that at all stages. And that's true for lawyers. If they do not have professional liability insurance and they are required to disclose that, they're also required to update that disclosure if at a future date they no longer carry professional liability insurance.
I
Yeah,
would
they should
prefer
know
to
that.
leave that in here and then
Me too.
require them to update it. Yeah.
And, okay. So that's the requirement to update is in B. Is that right?
The requirement to update, yes.
Okay.
So,
Okay, so that's what we have for mandatory disclosure. So what additional would we have for an informed consent?
well, we identified 2 things. The reasonable estimate of total costs is, and the existence of any financial arrangements, which, by the way, is actually, they're required to do this under other rules as well. So this is a bit redundant. Under 1.5.1, there.
It's existence of financial arrangements, reasonable estimates of cost, and then the specific limitations on the license based on the practice area.
So if we're talking about 3 different writings, we've identified what potentially could be in a mandatory disclosure at the beginning of the relationship. What are we requiring them to disclose in this second writing, informed consent? All of these things, again, in addition to the reasonable estimate of costs and the existence of any financial arrangements. And then it sounded also like a more tailored disclosure of risks, but I'm not sure exactly what that would be.
Well, I do think we would want a more tailored description of alternatives. I think that's the big one. So in other words, if there's a flat fee attorney that does debt collection actions for $800 that we heard about from the debt collection case, or similar for the UD representation, if this paraprofessional is going to charge just as much or more, it seems like an obvious thing that would need to go into an informed consent, that you can have an attorney for the same price or less. So again, more tailored alternatives once they have information about the case and know what the alternatives are. Oh, you might qualify for X, Y, or Z.
I have a little bit of an issue with that, just because there is, to some degree, you know, the requirement, and I know that that's why we have this whole thing that individuals should be looking some things up on their own too. Amos, I mean, how would I don't know any other profession that has to go and figure out what all the other options are around them and then be able to give client service like that. That's over and above even the scope of what they should be doing. And I mean, I think that puts them in a really bad position. What if they missed one and they didn't know it, and then they're going to have action taken against them just because they weren't being educated in, you know, what's all of the options out there for individuals around them. So I really struggle with that one.
I do as well. And let me just say, I mean, not to give work to the state bar, however, wouldn't it make a whole lot more sense for there to be a central repository of information, for example, on the state bar website about the different kinds of providers or resources in various places, and that the paraprofessional would be required to include information about how to access that, for example, a URL as part of the disclosure, and the responsibility lies with the state bar to keep that updated, as opposed to, I just don't see how we have this be the responsibility of individuals. I don't see how they do it. I don't see how we rely on them to do it properly. And I don't see how we discipline them, you know, appropriately. However, I think there should be information available to people that, you know, ideally there would be information, available, and the paraprofessionals would be responsible for giving a link to that.
Yeah, and right now the State Bar website does have information about all of its grantees. These are the programs for free legal services. I think the low-cost attorneys is much more challenging because there is no requirement that attorneys report to the State Bar on the fees that they charge. And so I do think that that one is particularly difficult. And I don't think a paraprofessional is going to be able to figure out what attorneys in their community charge. And the State Bar
absolutely
isn't, unless we change rules and require attorneys to report fees, which would be very controversial.
And
yeah, which is back
sorry.
point of, I don't see how they would possibly expect them to do this. Sorry, Farida.
No, I apologize. So I agree that this should not be required. I think that this falls under, don't hire me, look at all these other great alternatives. I mean, I just don't agree that we should do that. But I agree that maybe we want to require them to include just basic information about the State Bar, their local court. However, if a paraprofessional practices in everywhere in California, that's maybe the information about the local court in which the case is based. A judicial council actually may be better because they have a link to every court, and most local court websites have all kinds of resources. I know we do. We have local resources on all kinds of issues. Low-cost attorneys, our lawyer referral service has a modest means panel. You know, so I think just general link to these basic resources is probably reasonable to require, rather than specific information about this lawyer charges $800 to do this kind of case, or this legal aid can represent you in whatever case. I just, again, too onerous.
And just to be clear, I'm not opposed to giving alternatives, just to the level of Amos, what you were saying, that specific, that's where I have concerns.
I love the idea, by the way, just to be clear of what Justice Patru is saying, if there was a link and somebody had this information all gathered, somebody else was taking on that burden. I just think, again, fundamentally, it needs to be an informed choice. And so I do think the harder question is, what does the disclosure say and how can we standardize that to make it easier for paraprofessionals? But ultimately, the consumer needs to be able to make an informed choice.
So before I ask my question, I'm going to ask another question. Is there a different section of this rules proposal that this rules draft that I should be scrolling to? Right now, this header is mandatory disclosures and informed consent.
Yeah, so as I explained, I think we're now breaking it into 3. So I think the best way to do it would be to copy and paste this rule and to have one called initial mandatory disclosures. And that's what we just got finished talking about. And now I think we're changing and saying, okay, now for the informed consent, what is that going to require? Is it going to be all the same things? Are we going to narrow it? Are we going to have more details? Again, I think it's overkill to have 3 different rules, but that's what we're currently discussing. We may decide to limit it or combine them more in the future, but right now I think the way to capture this discussion is we've now talked about a separate initial disclosures that we hadn't discussed before.
Just to be clear, I think we should have disclosures and then a written agreement that contains some additional statements that you wanted to be in the informed consent, but I no longer believe that we need informed consent as defined based, again, what I've learned today.
So in other words, combined. So again, this is what I was saying. I don't feel comfortable making that decision now. I'd like to not do that because that requires further discussion. But yes, one possibility is to now have a new initial mandatory disclosures and then to combine the written agreement, the mandatory disclosures, and an informed consent requirement into that other rule that we have.
No, I don't agree with there should be informed consent requirement as defined.
Okay.
I just want to be really clear. Thank you.
Okay, fair enough. So again, before we do that, but right now to capture what we've done, we have 3 draft rules.
Should we, and this might be helpful for Kim, to go through rule 1.5.2, the written agreement, so that she has some sense of what that rule requires?
Yeah, that's great. And just again, I think that would be very helpful. And just for background, that rule, separate from an informed consent requirement, that rule was based on the current rule for attorneys, which is in a business and professions code. So there currently is a written agreement requirement for attorneys in a statute. That's not in the rules of professional conduct. And so the intent, at least initially in drafting this, was to track those rules in the statute and put them, have a written agreement requirement for paraprofessionals as well. Although we may want to suggest legislation to do that as well, to parallel what is done for attorneys. Because, and one of the issues is because, again, violation of having a written agreement for attorneys, by statute, it's voidable. Here, we haven't at least drafted that requirement. And I think the only currently drafted would be just discipline. So Greg, if you don't mind, I'd like to also add, if you think we might be able to have this agreement be voidable, have a voidable alternative for a remedy, I think we should try to think through that as well.
Yeah, I don't know what the answer to that. I know in other states, they, in their rules of professional conduct, they do have that as a remedy, as a potential form of discipline. But I don't think we've done that in California, unless Andrew and Randy think I'm wrong, which is quite possible.
Randy had to leave to attend to an item at the board meeting. He should come back when he's done. I will just say, under the purpose and function of the rules of professional conduct for lawyers, Rule 1.0, it's quite clear that the rules are only for the imposition of discipline. And in fact, under 1.0b3, it states a violation of the rule does not itself give rise to a cause of action for damages caused by a failure to comply with the rule. Nothing in these rules or the comments to the rules is intended to enlarge or restrict the law regarding liability of lawyers to others. It doesn't quite get at the specific question of voidability, but I think it's close enough to show that it's not the rules aren't used for civil remedies typically. There's a little bit of a wink and a nod because these rules are often cited for civil remedies, but that's at the discretion of the judge to use those standards to either exclude evidence or disqualify an attorney, as just two examples. But the voidability of a contract and the rules of professional conduct, I think that would be unique in California.
Yeah. And just to give additional background, Kim, so the requirement for attorneys, as Amos alluded to, is in the State Bar Act, Business and Profession Code 6148. They're required to enter into a written agreement if it's anticipated that the legal services will cost more than $1,000, which essentially sweeps in most attorney-client relationships at this point. And also 6147, any contingency fee agreement also has to be in writing, and the statute sets forth the elements that need to be contained in the writing as well. So we've replicated some of the, I think all of the elements that are required for a written agreement for attorneys in the rule, but there's some additional ones that were part of a rule that Amos had proposed earlier, I think in October. So let's just quickly go through this rule. Again, prior to the performance of legal services for a fee, this is when the trigger point is you need to enter into a written agreement with the client, signed by both the client and the licensed paraprofessional, provides their name, specialty area, and their license number, and includes the following provisions. One, a general explanation of the general nature of the legal services to be provided. And as my note says there, this is based on a similar requirement. It's actually very similar language to the statute, 6148. Does anyone have a comment on that, or should we continue? Okay. Two, a clear and conspicuous disclosure that the licensed paraprofessional is not a lawyer. So here again, we're making that disclosure. May only provide limited legal advice and will provide limited advice and assistance in preparation of court documents and related tasks. My note there says, does this actually reflect what a paraprofessional is authorized to do? That was just a question because we were still, I think when we were originally drafting this, we were still defining the scope of practice. So I think it does. Limited legal advice and assistance in preparation of documents and related tasks. The statement shall be on the first page of the contract in a type size, font, color, appearance, and location sufficiently noticeable for the client to read and comprehend, in a print that contrasts with the background against which they appear, in larger type than the surrounding text, in a manner that clearly calls attention to the language. And that, I think, is from the proposed rule that Amos had circulated last October.
So I was wondering if this is where we need to sort of recognize the different specialties, because I think from when this was drafted to now, the full group has voted to allow full representation as a default position, and then leave it up to each subcommittee to decide if they're going to opt out. So it's not just limited to limited legal advice and assistance with preparation of court documents. Does that make sense?
Yes, it makes sense to me. Okay.
So also, because every practice area is going to have their own rules. So UD, you can represent but for trial, and family law may come up with, oh, full representation, or we may even divide it into issues. I don't know yet. Should this then be divided according to practice area, or just say something generic like depending on the practice area? And then in the actual written agreement, we sort of think about coming up with some standardized attachments. Let's say C attachment, and it'd be like family law or UD or the other specialties.
I suppose what you could do is just say a clear and conspicuous disclosure that the licensed paraprofessional is not a lawyer and may only provide limited legal advice and services and leave it as, I'm hesitant to tailor a rule to each type of licensure. I think what you could do in some of the commentary, and this might be an area where we are adding a comment that doesn't appear in the lawyer rules, is indicate that there, state bar may provide form agreements that would, because this is one area as opposed to risks or alternatives where we're imposing potentially a burden on the paraprofessional to know exactly what those risks and alternatives might be. Certainly the alternatives. They should know the scope of their license. They should know what they're authorized to do. And so I would imagine this could be a standardized contract that they have in their own files, and also that the state bar could probably put together fee agreements for each type of licensure that also includes some language describing the limitations on their area of practice, if that makes sense.
Okay, yeah, but as far as the language for this rule goes, I think what you've mentioned or proposed is better than this, what it is there now, based on what has transpired since we drafted this. What do you think, Amos?
Yeah, no, I agree with Greg. So what I think we intended for HEBA, although now it has been quite a while, is this is to be clear what the limitations on the license are, right? So what they can and can't do. And it used to be we had the scope of practice and the prohibited acts, but that's been moved. So this is going to be the one place where the client is informed. This is what's included in the license. This is what's not. And that could be, there's no reason that can't be standardized.
So Amos, did you say you removed it? It used to say the scope of practice, because that seems like what we need, right, for the individual?
Yeah, so at the time we didn't have the scope of practice, so that's still being developed, but that's right. So remember, this is supposed to be a clear disclosure in large print on the first page.
Right.
I'm not a lawyer and this is what I can and can't do. And again, fundamentally, the idea was we don't want anyone to be misled or confused. So we want it to be clear. If it's going to be an exhibit that's a long list of things, that might be useful, but what we really want is a clear statement up front that make it clear that you understand. And so we need to, once we know what the different practice areas are doing, I think we could just standardize that.
They may, especially the family law paraprofessionals may have a hard time containing that on one page. Just looking at the authorized activities that subcommittee is already contemplating for that paraprofessional.
Actually, we are gonna turn it around and only list what they cannot do. There's so many things.
Well, that means that may be a better way to also do it here, that they can provide limited legal services, and these are the things they cannot do.
Yeah, exclusions. Yeah, for sure.
And is this the same type of further delineation of the limitations on the legal services that the paraprofessional can provide that we were talking about including in the informed consent? Is this the exact same thing?
Well,
so maybe. So again, informed consent is making it relevant to the client to decide. So there might be like, okay, you need somebody to represent you at a trial on child custody. And an informed consent would be, I just need to make it clear. I can fill out the forms for you, but I don't know what they decided, but it's letting the consumer make an informed decision. This is a standardized disclosure. So it may be that you may need to make the similar or same disclosures to get informed consent, but this is not an informed consent requirement. This is a standardized disclosure.
A standardized disclosure that is scope of practice specific, though.
Correct. Besides the paraprofessional is not a lawyer, the rest of this would be practice area specific.
Well, and this whole agreement would be very specific, right? Because you're going to lay out to some degree what type of services you're providing for the case that you're taking, right?
Yeah, that's A1.
Right.
Yeah.
Mm-hmm. So A1 is what I'm going to do for you. A2 are things I'm not a lawyer, and these are the things I can never do for you in this area of law.
So are you saying that A2 itself is going to be modified to reflect that by practice area, or that would be in a comment?
Well, I think the comment I made about a comment was that we may want to, in a comment, draw the attention to the paraprofessional, draw their attention to standardized forms that are provided by the state bar, fee agreements, by practice area. I don't think we want to, in the rule, try to include the limitations on the license. I think those are going to be in rules of court that set forth the scope of the license.
It sure makes it a lot easier to do it that way.
Yeah.
And then they have one that is on, I know that, you know, we have some that have like a practice agreement or standardized protocols, and to have that out on the website where they can go get it and use it. It's, you know, you don't put it in the language of the law, but you have it out there for them to use.
Right.
And it would be dated, so you know which one they should be using at the time. Like in the future, then they're going to change their scope or something like that. Yeah.
Right.
Right.
Should we move on to 3?
Yeah.
So 3 actually again reflects the 6148 requirement for attorneys. Any basis for compensation, including but not limited to hourly rates, statutory fees, or flat fees, or other standard rates, fees, and charges applicable to the matter. And that, again, just mirrors the statute. Any comment on that, or should we move to 4?
Good.
Okay. 4 was part of the written agreement rule that Amos circulated last year. What I added in was pursuant to Rule 1.4, which is the duty to communicate with your client, because that's already a pre-existing duty. So, but this is informing the client that you have that duty. So if you don't inform them and you don't include it in this contract, you could be subject to discipline. So it's a statement that pursuant to Rule 1.4, the licensed paraprofessional must keep the client reasonably informed about significant developments related to representation, including promptly complying with reasonable requests for information and copies of significant documents when necessary to keep the client so informed pursuant to Rule 1.16. Again, I think it's what I did here was really adopt the language of those rules, so it's very clear that it's consistent with the pre-existing obligations.
I like that change. Greg, can I ask a question? Does that also, did you make a conforming change to if the matter goes beyond the license? I think that was a different part of this.
Yeah, I think we're going to get to that at some point. Yeah,
because I think that would also comply with Rule 1.4, right?
Beyond the license would be 5.5 UPL. We've incorporated that. And so essentially what makes it a bit different than lawyers is UPL, they can engage in unlawful practice of law if they practice beyond the scope of their license.
Got it. Okay.
Yeah.
Can I just ask?
And go ahead.
Is this necessary to say what they are ethically obligated to do otherwise? And is there concern if you're excluding other ethical obligations that aren't being disclosed here? I'm just trying to make the rules as efficient as possible. Is there a particular concern that the group sees or is aware of that necessitates these 2 rules to be specified here? I'm not saying that they don't have this obligation. Of course they do. And that's going to be well understood in the rules that are otherwise adopted. I just wonder if it might be easier to, if this is not overkill, and you might want to consider removing that.
So I think it is going to be well understood by the paraprofessional, but this is the written agreement with the client. So the idea here is to highlight.
I'm sorry to interrupt, but can you, because I do have to go in a minute, and I have to step away for just 3 seconds. Which paragraph are you looking at right now?
4.
4? I can't. Oh, thank you. Sorry, Amos, go ahead while I reread this.
Yeah, so I was just going to say, I think you're exactly right that this should be, hopefully will be well understood by the paraprofessional. But I think the purpose of this written agreement is to put this in writing and make it clear to the client and just highlight certain things like that the obligation to, reasonably inform the client about significant developments is one that, again, providing a whole list of all the rules of professional conduct isn't necessary and won't be helpful, but highlighting that this is an obligation, I think is.
Why are we requiring it for, we don't make attorneys do this. I mean, why are we asking paraprofessionals? Why do we think that paraprofessionals should have to put this in this agreement or state it when attorneys don't have to?
I actually do think this is a standard term in most attorney representation agreements.
Are they required? And I'm sorry, I haven't been an attorney for a long time, and so I haven't entered into an agreement for a long time as an attorney. I'm not aware of, and Greg can correct me, I'm sure very promptly, some requirement that it be in there. And I'm also I'm not aware whether that's standard or not. And I certainly am not aware of a requirement. I think it just gets very dicey because there are a lot of requirements out there. And when we start picking and choosing what goes in the agreement, speaking for myself, I'd be just as concerned that I leave something out or that I somehow imply that something is not as important because I'm not requiring that it be in this disclosure as opposed to something that isn't in the disclosure. So I'm just concerned about missing something. I'm concerned about putting too much importance on something and therefore impliedly not putting enough importance on something else. And I have the overarching concern about, I do think it needs to be extremely clear to people that they're not hiring an attorney and the differences about what they can do or not. But these kind of overarching ethical things, like you have to let your client know what's going on. You got to give them their documents when they want them. You can't withhold records for payment, like all these sorts of things. I just don't know where you cut and paste. So that's my, kind of pointless speech as I have to go deal with an emergency writ. So I do have to jump off and do that. But just my last couple of seconds here will just be to thank everyone for continuing to work on this. This is not easy. It's really not easy. And clearly everyone's putting in their best efforts and I think is getting to a very good product. So that's my little 2 seconds. I will see you all soon. And I apologize that I can't stay for the duration of the meeting. Talk to you all later. Bye.
Bye, thanks.
Yeah, I think those comments are well taken. I'll just note again, as we mentioned, there is no parallel rule for attorneys because this is covered in legislation, mainly Business and Professions Code. So we're trying to come up with what we think would be the best parallel rule for paraprofessionals where, we can protect clients and maybe improve. I think one area is like information about malpractice insurance. I think Greg's has mentioned that there's been some concern about how that's often hidden in the fine print on page 3 and it isn't effectively disclosed. So I think this is our opportunity to improve where we think improvement is appropriate.
In response to Justice Petru's question about it, the statute requires what we already have in there, any basis for compensation provision, which we just covered. The first one, which is the general nature of legal services to be provided to a client. And the third required element for written agreement is simply the respective responsibilities of the attorney and the client as to the performance of the contract. So it's very generalized language as to what it means by respective responsibilities. I think different lawyers interpret that differently, and I think some disclose that they have an obligation to turn over the file at the conclusion of representation. Others don't. Again, that the statute isn't written as a disciplinary rule necessarily. So it's something that's interpreted, and usually I think most of the controversy around the statute comes down to whether or not there's even a written agreement at all, not so much as to the elements that are in the agreement.
I also am concerned. I think these two really important duties, of course, both to make sure paraprofessionals and also the clients. So, but I'm concerned that there are other rules that are just as important and should be, and the clients need to be informed of. One of my pet peeves is that attorneys have to sub out. They can't refuse to sign a substitution of attorneys, but often they don't. And so I'm just wondering if we need to be so specific and pick these two to be specific on and then leave others out. So
Well,
I'm taking that point, yeah.
The next three actually have to do.
Yeah,
with-
4,
in a
5, and
similar
6.
vein, Actually.
Yeah,
I mean,
4,
if you
5,
think this is important, you could just simply say a statement that a licensed paraprofessional is obligated to comply with the rules of professional conduct for paraprofessionals. That, I mean, that would capture these sub rules as well as every other rule, and it would put the client on notice that there are professional standards that the person they're hiring must abide by.
But it wouldn't provide any type of consumer protection or useful information to the consumer. So I do think technically,
Well, they could go
from
look
an
up the
ethics point of
rules.
view, yeah, exactly.
they can provide a
consumer
link.
who is
to the
hiring a
rule.
paraprofessional could look up and study the rules of professional conduct, but I don't think that's reasonable. I don't think there's any reasonable basis to believe that that would provide any kind of information to the consumer, useful information to the consumer, or any kind of consumer protection. So if we want to just limit it to what attorneys have to do, I'm fine with that decision, but I don't think we should pretend that we're providing additional consumer protections when we're not.
I have a question, just actually for clarification, that 1.16, 1.16, is that right now in what I have is declining or terminating representation? Is that the wrong
No,
section?
That reference should probably be removed. I agree.
Well, the reason that is there is because part of 1.16 is the obligation at the conclusion of representation to turn over the file.
Oh, okay. All right.
Yeah.
Sorry, I missed
You have
that.
a more pinpoint site there, which would be E1.
Another thing attorneys
And then
often don't do.
2 is actually.
But you have
site-
the language when necessary to keep the client informed pursuant to that rule. That's
more of a turnover.
more of a 1.4 obligation.
Yeah,
1.16 is at the time of termination, you got to turn it all over.
So 1.4 is the duty to communicate, but that it includes the ongoing duty to provide any significant documents upon reasonable requests. So a client can't ask for their file over and over again. So that's during representation. 116 focuses on the end of representation. And at the end of representation, you have an obligation to turn over significant documents and also refund any unearned fees. And as Justice Patru mentioned, which we have seen in many cases, you can't hold the client file hostage until they pay their fee.
I think.
I actually have a question for you, Andrew. Like, what is the downside of putting it in here?
Well, I think it's just the concern of you're excluding other important rules. You're subjecting the person to discipline for overlooking a reference to perhaps 1.4, but yet including references to 1.16 and 1.6. And frankly, just over regulation. You could have all kinds of disclosures. You could make this document quite robust. But again, going to my experience with revising the rules of professional conduct back when they became operative in 2018, instruction from the court to us for rules of attorneys was minimum standards for discipline. And so, are we achieving that goal by hyper technicalities on specific disclosures as opposed to others? Of course, reasonable minds can differ. I think there are easier ways to go about it, but it's up to the group to decide.
And I think one other risk maybe that, or concern maybe that the client may think these are the only rules versus a general statement that was just suggested will inform the client there's a host of rules ethical rules that have to be followed.
And then of course, the resources of the regulator, complaints can come in for any of these violations, and you have to develop standards of discipline for when these violations occur. And I don't disagree. Failing to communicate under 1.4 is a serious violation, and that's one of the most common we get, but that obligation is going to exist whether or not you have subpart 4. So.
And I do agree, by the way, this is an area, and I would like to officially include it on the list of proposed legislation, because I do think we probably need a business and professions code statute that parallels 6148 for paraprofessionals, including because of the what you're raising, Andrew, which is this here is the minimum standards for discipline, and it's a disciplinary rule, whereas there are other remedies and consequences of violating the business and professions code. And I would argue maybe it's a legislative argument instead of a disciplinary, rules of professional conduct argument, but some of this stuff is important as a consumer protection to disclose to potential clients.
Should we move on to the next one? Because the next two are actually similar. They're citing to other duties. 5 is a statement that the licensed paraprofessional's duty to protect the confidentiality information related to representation under 1.6, including information provided in confidence by the client and the licensed paraprofessional's work product associated with legal services sought to be provided by the licensed paraprofessional. So this is essentially putting them on notice. We have a duty of confidentiality similar to that of attorneys, and we will protect your secrets.
So I have two observations. I meant to raise this on our other list as well. So my first is a reference in this particular subpart to work product that might lend confusion with work product protection, which is in the CCP code. And I don't know if that would apply without a change to, if that protection would apply to paraprofessionals. And I think we should make a note. I don't know if Leah's still taking notes, but if there were not to be a paraprofessional client privilege that's ever adopted, I think that that's an important disclosure. It's not just that you're not hiring an attorney, but here's a protection that you would get with a lawyer that you might not be getting with me as a paraprofessional. That's something that's afforded in the law and in statute. The duty of confidentiality will be imposed on paraprofessionals through a rule, even though we might not have a statutory change. And so others might disagree, but personally, I think that would be an important disclosure. Should there not be a privilege available for communications between a client and a licensed paraprofessional, I think that that is something worthy of disclosure.
And that's a good reason why the rules come last.
Exactly.
The rules are going to have to reflect what the legislature actually does or doesn't do.
So that's one point. And the other is just this phrase work product. I might be overly sensitive to it, but there's might unsophisticated client be like, oh, I have a work product protection. You made some other mistake. Maybe I'm overthinking it, but I think the duty of confidentiality, most lawyers and definitely all ethicists know that that is broad enough to encompass everything, even things that aren't communicated to you by the client that would be embarrassing or detrimental to the client, or the client asks that you not share. And so that's this phrase work product that's a little off-putting, but we don't have to wordsmith it and waste our limited time on that. I just raise it as a potential concern.
The other point is that work product is actually the holder of the privilege is the attorney, not the client. Which is a bit different than duty of confidentiality.
Well, I'm hoping that you all are planning on, proposing legislation that adds that. Because here we are saying, hey, paraprofessionals, you can give legal advice and you can represent them in court, you could do the forms, and we're not going to give them the tools that attorneys have, such as work product privilege and all that.
Well, work product privilege and attorney-client privilege, that has to be created by the legislature.
We are going to propose it, though, Greg.
Yeah, they're going to propose it, but it's not something that we can we can impose a broad duty of confidentiality on attorneys. But when it comes to evidentiary privileges, the legislature has to weigh in on that.
So I want to do a time check. It's 2:13. I don't know if we can get through this rule and then go to the, like, trying to take stock of where we are, figuring out what else we need to do. Is that possible? Or no?
Well, I leave it to the group what they feel is most productive. It sounds like Amos wants to wait to discuss, to as a group come to some consensus around how are we handling mandatory disclosures, informed consent, and written agreement. And it probably would behoove Kim to have some time to think about this more too with some of these materials. So it's up to you if we could put this aside and look at the bigger picture of where we need to go from here.
Right. Do you think we have time in the remaining minutes to get through this particular rule we're on, written agreement, and then do the sort of inventory discussion, or we can't do both? That's my question.
I would say no, based on the conversation we've had over the over the prior provisions that we've already gone through. I think it probably would be advisable if we want to, at this point, talk about where our roadmap. We should probably use the remaining 15 minutes to talk about it, and then we can pick up where we left off. We'll remember that we left off here at A5, I believe. A5. Yeah.
Okay.
So, but again, it's up to the group. What does the group wish to do?
I don't think we can probably get through. I
don't want to rush it either. I think we do need a roadmap.
Okay.
Okay.
So Greg, you sent to all of us the issues list of what's remaining to be covered.
Oh, I only sent it to you because I'm so well trained not to send it out to the group to start a serial meeting. So
okay, let me do that. Sorry.
That's all right. Can you?
I can share it too, but I'm not.
Why don't you email it and I'll share my screen and then we
Okay.
can look at it together. Since I now am so well skilled in this. Let's see. I think it's that one. Can you see it? And let me shrink it again, or I mean blow it up. Okay. So as I said, there's 17 rules in which there's some particular issue that we need to cover. And then we need to talk about how to address the comments. And I think the proposed changes to the lawyer rules is just more of a note for me and I think staff than anything else, because I think it'll be very clear what those changes would need to be, or hopefully it will be. So some of these are not big issues. We should be able to dispatch with them fairly quickly. Others may take a little bit more discussion. We have been talking about this one obviously quite a bit, and we need to come back and make a decision on that. How many meetings do we have between now and when we need to have a final set of rules?
That's what I'm looking at. So I see that we have meetings the 20th, the 27th, the 3rd.
And there aren't any more scheduled beyond the 3rd, because
Yeah,
I think this was to prepare for the June 25th meeting.
Okay, and so we have 3 more meetings scheduled. We would need to, not meet after the 18th in order, really after like the 16th, in order to try to have something ready to post for the 25th. But we could probably fit in a couple of other meetings after the 3rd.
My suggestion with the comments is that we just not try to, try not to deal with the comments as part of the presentation on the 25th. We can easily get bogged down on the comments. I think we continue to focus on the black letter rules and the regulation subcommittee. Once we get consensus from the working group on the black letter rules, we can circle back to the comments. Does that make sense?
Farida, Amos, Kim.
It's fine.
I think that makes sense, yeah.
Okay.
And then, as I said, we have 17 rules. We have 3 meetings.
Scheduled now, yes.
Okay, so I think so that means we need to try to cover at least 5 of these rules per meeting at least. What I should propose that I'll go through this list and try to organize them based on hard, medium, easy, and see if we can get a mix of at least the 2 more difficult ones and then maybe a medium one and an easy one. And hopefully we'll be able to cover them in 2 hours. Some of them we've already started to discuss between Fariba and Amos, but I don't think we came to a complete consensus, or we've received feedback already from the working group that we need to address. So for instance, a licensed paraprofessional, whether or not we need a definition for that, that's more of a kind of I don't know if we need to really debate that much. We don't define lawyer in the rules of professional conduct, partly because it's defined under the evidence code and there's a pretty good understanding of what we mean by lawyer. There may be a need to define what a paraprofessional is because it's a new profession. And so it's clear, but Professor Moore, I just highlighted that. Some of the other issues like the competence issue, they're under Rule 1.1, there's a provision allowing attorneys to provide emergency services, legal services under certain conditions. And there's probably good arguments on both sides as to whether or not we would want to authorize a paraprofessional to do so within the scope of their license, of course.
By emergency, you mean there's no time to
no
sign
time
a
to enter
contract
into
or
a written
something?
agreement, like somebody needs something filed today and they're in desperate need. And so there is a bit, it's basically a safe harbor on the competency rule that we have for attorneys. So we could talk about it. We don't want to dig into it too much, but that's essentially what that means. I know as a general policy decision, we have decided that we would want to allow for limited scope representation by paraprofessionals within the practice area. I think this is an easy one if that's the decision, but that it's a question that was raised by Professor Moore within the context of Rule 1.2. So we'll have to, that would probably be one of my easier ones for us to deal with. We just need to come up with a final decision on Rule 1.4.2 and 1.5.2.
That's probably one of the easier ones, Greg.
That's not one of the easier ones, but we have exhaustively discussed it.
Yes.
So I think we need to just come to a consensus. Hopefully, Kim will have a more informed decision, be able to make a more informed decision perhaps at the next meeting, and we can limit our conversation and really just make a final recommendation on what we want. Do we want 3 writings? Do we want 2 writings? And what are the requirements for each writing?
Okay, and I see you have the same question I did, like what are we talking about here for 1.5.1? Are we just talking about paraprofessional, or are we talking about paraprofessional lawyer paraprofessional?
Oh yeah, I mentioned 1.5.2, which is the written agreement, but yeah, you're skipping ahead to the, yeah.
Okay then.
But we'll move on. So 1.5, the legal fee for legal services. Professor Moore made a point that one of the factors that we have included for an unconscionability of a fee is a factor that appears in the ABA model rules that really goes to more of a question of reasonableness than unconscionability, and whether or not, and it's something that we don't have a factor that does not appear in the lawyer rules, and whether or not we want to have that. Also, probably a bigger issue that came up from the full working group is whether there should be a cap on contingency fees, but we may be able to table that because I think that we're going to have a conversation about fee caps in general next week as a working group. So that may be prove to be easier. This is another difficult one that we've talked about quite a bit, and looking forward to get Kim's feedback on this, but it's actually multiple issues here. Fee divisions among paraprofessionals. Do we want to permit them to share fees? If so, do we want to include the model rule requirement that the division has to either be in proportion to the services performed, or that each paraprofessional has to assume joint responsibility for the representation? If we impose that requirement, pure referral fees are forbidden. They just go away completely. If we don't, and we follow the California lawyer rule, that simply means the division has to be put in writing in a way that's understandable, and you need to obtain, and the total fee can't increase, and you get informed consent. Then that opens the door to pure referral fees just between paraprofessionals. So,
And Greg and Amos, where did we, I thought we, now I'm remembering that we talked about this extensively. Where did we leave it? For whatever reason, I cannot find my notes.
I don't know if we really came to a decision on these things. We talked about them, but I think we were trying to untangle these issues, because this is the way. So that's one issue. And then the other issue is whether to permit fee sharing between a paraprofessional and a lawyer in different firms. And again, the first one, by the way, is fee sharing among paraprofessionals in different firms. All right. So this whole rule has to do with people being in different firms and sharing fees. 5.4 deals with people in the same firm. Okay, so.
And sorry, wasn't there a third option that not to allow anything at all since the program is new?
To not allow any, yeah, well, that's one option, is to not allow any pure referral fees, but that doesn't answer the question of whether or not you want to allow fee sharing. And there's very good arguments for allowing fee sharing among paraprofessionals.
Right.
Right. So, but this is a bit different. So if we don't want them to get pure referral fees, then we do want to impose this requirement on them right here, which would be the ABA model rule requirement, which is has been adopted by a majority of US jurisdictions as well. But now you can have a situation where you allow paraprofessionals to have pure referral fees back and forth, but not allow pure referral fees between lawyers and paraprofessionals. And I think that's what Steve Fleshman was recommending, but wasn't entirely clear. So that's another issue that we need to decide.
One more question. You also talked about fee splitting.
It's fee splitting and fee sharing. It's two ways of saying the same thing.
Oh, okay.
So so a pure referral fee is considered a fee share. It's just a fee share where you're not taking responsibility for the matter, or doing work in proportion to the fee that you're receiving. Okay. So we'll have to come to some consensus on that. That's probably one of the bigger ones. Business transactions and pecuniary interests adverse to a client. There's been some questions raised as to whether or not we do want a rule like this for paraprofessionals that would allow these types of business transactions as long as it complies with the rule. And the specific instances in which a paraprofessional needs to place a lien on a matter to secure fees. That is the most common pecuniary interest adverse to the client that we see. So we'll need to circle back on that because there were some issues raised about that.
Is there any data or information available on how useful it is to have this between attorneys and clients? Does this happen often? Does it help the client? Versus forbidding it altogether? That's what I mean.
So there's, I don't know if we have the data, but part of the policy reason is to protect the client, because a client reposes a lot of trust in their lawyer, who is their fiduciary. And there have been cases where lawyers have gone into business transactions or taken adverse pecuniary interest against the client before this rule was enacted, and the client was subjected to harm. Client says, oh, you're my lawyer, I'll give you my money. Please invest this in the land property deal that you have with your sister, but that's not disclosed, and they divide it into 4 pieces and loses all the client's money. Lawyer says, oh, you can't pay me, don't worry, I'll just put a lien on your house, it's okay, I'll deal with the bank, I'll get it from them, don't worry about it, this way you can allow me to represent you. There are a variety of examples, and this is just a really quick way to try to describe it, but it is to protect the client. Do we have data on the harm or what have you? No, but it's a public policy, and it's.
I totally understand the reasons for having it. I'm just saying it versus banning it altogether.
Yeah, and I think we should reserve, let's not talk about the actual rule at this point.
Yeah.
What I'm trying to do is give you a just quick landscape of what we need to discuss. And
So,
there's this many more rules to talk about, just so I guess because we only have 2 minutes left, I think what we'll do between now and the next meeting is try to organize these issues, as I said, into the hard, medium, easy ones, and see if we can somehow schedule out when we're going to talk about each of these things. And maybe even put a time clock for us on each of the rules, hopefully that we can reserve ourselves, confine ourselves to for each issue, so that we're able to get through these issues. Because we can talk about them as the Rules Revision Commission did ad nauseum, and it can take a long time. So at a certain point, we just need to make a decision on some of these things.
And I also recommend that Greg or Leah previously distributed a draft. So there is a working draft of these rules with many of these as comments. And I do think it helps to just review the draft rules and sort of what's already redlined against the attorney rules and comments, which I think, Greg, you basically, captured most of those in this document. But I think it's helpful to actually look at the draft rules, see where they're redlined against the attorney rules, and see the comments in that context.
I agree. I think Leah sent out a version with Kevin Moore's comments as well, and then my responses to his comments. And Leah, did you send that out?
I did. I sent it a while ago. I just sent it to Kim today, but I sent it to others a while
So
ago.
what we'll do is when we send out my proposed schedule for these things, I think we'll just send it out one more time so you have it at your fingertips.
Okay, and yeah.
You'll send these questions to us, Greg, so we can be thinking about it before we meet.
Yes.
I sent it to you.
Mm-hmm.
Is that what you're talking about? Or
Oh, you did. Okay.
Right now.
So should we plan to try to do at least one more meeting after the 3rd? Maybe for the 10th?
Probably a good idea.
Okay. So Linda can do like a doodle poll, but I know Thursdays are a good day for Ken.
Is Thursdays at 10? That's the time that we generally have been scheduling these meetings. Does that work for everybody? The 10th?
So I have on my calendar on June 10th, we already have a 1 to 4 meeting. I don't know which is that the full working group?
Well, that's the full working group. So maybe that's not.
Yeah. So Linda, let's do this by email because
Okay.
yeah,
All right.
be respectful of people's time.
Okay. Thank you.
Okay. All right. Thank you.
Okay. Thanks, everyone.
Thank you. Bye, everybody.
Bye.
Bye.